Good morning. Welcome to Bracewell Environmental Strategies Group Environmental Essentials webinar. Thanks for joining us today. I'm Tim Wilkins, the managing partner of the firm's Austin office. I'm a 25-year environmental attorney who's worked on a lot of environmental enforcement actions, which will be our topic today. I think as most of you know, this is our monthly quick hit webinar for busy EHS professionals on topics of concern to their employers and clients. I should mention, when I say it's a monthly webinar, we will not be doing a November webinar because we're hosting our twice annual half-day seminar live in the Houston office of the firm on November 14th. I hope you will all consider attending. If you need details, please just email me. Our next session will be December 10th, where our DC partner, Ann Navarro, will talk on the topic, why should I care about the federal process as long as I get my permit, focusing on how private projects can get tied up in federal litigation. Today, as mentioned, we're going to be doing the basics of environmental enforcement defense, a topic that is broad that I've narrowed to fit the time we have. The enforcement scenarios we're going to cover are about violations of regs and permits, not Superfund enforcement, not criminal enforcement. We'll consider federal, civil, and administrative enforcement with EPA, not other federal agencies like the Corps and so forth, and state administrative enforcement. And I'm going to use the lens of TCEQ, the Texas Commission on Environmental Quality. I think most folks on the phone have Texas facilities, so it's hopefully relevant. Other states are going to have similar agencies. I'm not going to be covering other Texas agencies like the Railroad Commission. But the themes that we'll talk about are themes that you would recognize in any of those other enforcement settings. So with that scoping, we'll talk today about how enforcement begins, what the different processes and on-ramps are to enforcement, and then primary defense considerations you want to take into account once you're in enforcement. So before we dive in, why do we care? Well, enforcement is a big deal. Penalties, for starters, can be very significant. The statutes provide for per day, per violation penalties, and those numbers, those maximums for Texas are $25,000 under many of the statutes, more than $50,000 per day per violation on the federal side, and those can add up fast. Federal enforcement in particular often involves very high penalty dollars. Enforcement actions are also a huge distraction. It's a drain on your EHS resources, on your legal resources. Your enforcement track record factors into formal Texas compliance history scores, ways other states, other agencies evaluate you, and those can come back to haunt you in terms of enhancements in penalty policies and future enforcement, and it can be an obstacle to permitting for go-forward projects. You can also suffer reputational damage from enforcement that can be very significant, especially if the company's in the spotlight for other reasons. I think we've all seen, the first day of news reports after an incident where they say, wow, that incident was really bad. And then the next day there's a report that says, oh yeah, and they've got a long track record of violations, and look at the state who didn't punish them very hard, right? Its reputational damage is real in the enforcement context. And then I think just to sort of wrap it up here on the why it's a big deal, it's a big deal because you have to not just make a compliance effort and be in compliance, but it's a big deal to be able to demonstrate that you're in compliance. If you are asked, if you are pressed, how do you prove it? And we'll come back to that in a minute. So, enforcement proper. How does enforcement begin? Again, I'm talking through the federal EPA lens here. The most common ways are inspections, where a physical employee of EPA or one of their contractors or both visit a site. That can be a routine inspection. They're looking at big facilities that are in a region, that are in an area that they're concerned about, or it can be complaint driven, where a neighbor or a whistleblower or somebody has flagged for the agency that there's a concern. There are reported events. Typically, these are like release reports, RQ releases, or spill reports that are made to the National Response Center. EPA follows up with enforcement in those circumstances. Additionally, if there is something that they're concerned about that they've seen on paper, if there's something that they've heard about that they're concerned about, they may send an information request or a show cause letter, which is the start of an enforcement process in most instances. And it can be some combination thereof. You can have an inspection that follows a release report that's followed up by an information request, right? These aren't three separate ramps. They're three ramps that can get you there, and there is crossover between them. At the state level, again, the TCEQ lens here, inspections, again, routine or complaint-driven. Reported events, RQ reporting to the state or still reporting to the state. And then your regular periodic reporting. This is very, very common with TCEQ, that your discharge monitoring reports under the Water Act, your deviation reports under the Clean Air Act, report something that shows an exceedance or shows the deviation from the requirement. Those are very common ways that TCEQ will get started on enforcement actions. I do want to do a little side note here. We've talked about inspections a little bit. How do you handle and respond to agency inspections to best position yourself for a good enforcement outcome? First of all, if an inspection is announced, and they usually are, you need to prepare hard. Get your documents in order. Don't just assemble them, but make sure that they're really orderly, that you understand where everything is, that they are a complete record of everything that you expect the agency is going to look at, and drill on this. Sit down and ask yourself the questions that you expect an inspector to ask, and be ready to answer those questions. When the inspector arrives, participate in their opening and closing conferences. Ask questions about what they're concerned about, what they're interested in, so that you know how to best answer any questions they may have. Speaking of answering questions, do be open and cooperative. Always be truthful, but don't volunteer and don't speculate. When I say don't volunteer, I mean if they ask you about A, if they ask you about this waste stream, answer that waste stream. Don't answer about other waste streams you may have. And I say don't speculate. If you're not certain about something, don't say, well, I think it's, because you might be wrong. Go say, I don't know right now, but I'll find out, or I'm not certain right now, but I'll find out, and get the actual answer. Take careful notes throughout the process so you know what they're asking about, what they're concerned about, and know what documents they're taking away with them. Keep a record of that. At the end of the inspection, verify any follow-ups. What have I promised during the course of the inspection I'm going to provide, and ask if there's anything missing from that list. Send an email to document what those follow-ups are and to get confirmation that that's your shared understanding with the agency. Once the inspector has left, knowing what you know, knowing what they were concerned about, knowing what documents they took, do your own privileged inquiry into these issues. Get your arms fully around the facts. Make sure you understand all of the circumstances that are relevant and the key legal positions. And make sure you do that before any relevant deadlines pass. There are often deadlines of getting stuff done of 30 days or the like. So let's turn to the EPA process and some of the pieces of this. After an inspection, the EPA process typically involves the production of a draft inspection report, and they'll send you a draft. It is not an invitation to redline their draft. They're not going to be receptive to that. This is typically going to include a list of who they talked to, a description of the scope and of the facility. They're going to discuss observations relative to the regulatory framework, and they're going to list areas of concern, or AOCs. Those AOCs are the counts that you would expect to see in an enforcement action. They'll also describe any follow-up that's expected. These inspection reports could be 3 pages long at a simple facility with a simple inspection, could be 50 pages, could be more. It just depends. The AOCs are the inspector's likely counts, which will be reviewed by the program, enforcement management, and by the Office of Regional Counsel, the legal folks at the EPA, to determine whether to proceed to formal enforcement and on which counts. You also have the information requests. Here's the header of one of those from EPA Region 8. This is going to be a letter that starts by describing the statutory authority for requesting information, Section 114 of the Clean Air Act, Section 308 of the Clean Water Act, and why they're issuing it. There's going to be a list of instructions and definitions, which will be very broad, and there will be a requirement to certify your answer under penalty of perjury. There's a confidential business information opportunity where you can flag CBI. There is then going to be the actual list of questions. It's going to be a numbered list of questions that you're expected to respond to individually. Typically, they're asking, who's who, what happened, asking regulatory relevant questions about particular issues or processes. And they're attempting here to elicit admissible information, to lock in your story, and to gather documentary proof to support an enforcement action. Not all information requests are the start of an enforcement action. There are sometimes regulatory reasons they want to ask and learn about an industry, but 90% of the time, probably more, the information request is the start of an enforcement process. So EPA, after getting those things done, may choose to issue a notice of violation, or they can just go straight from the inspection report or straight from the response to an information request into negotiation of an order. And there are several types of orders that EPA uses administratively: a CAFO, which is a consent agreement final order; AOC, which there's another definition of it here, administrative order on consent, not area of concern; or expedited settlement agreements, which are sort of the traffic ticket version of these. It depends on the severity, depends on the remedies they're seeking as to which one of those they use. Also, depending on the severity, the timing of injunctive relief, if it's something that's going to take a long time to correct, or the amount of the penalty, EPA may pull in the Department of Justice for formal civil enforcement. In fact, for some circumstances, they have to pull in DOJ for civil enforcement. That's going to include a complaint filed in federal district court, and what you end up with is not an administrative order, but a consent decree that goes out to the Federal Register for public comment and is finalized and issued as an order by the federal district court. So DOJ referral can be a really, really big deal. Let's talk about how to respond to EPA inspections and information requests. First, further information is going to change hands after an inspection. It's a natural part of the process. You should not expect the inspector to always issue a formal information request. It can happen, but informal is fine so long as you treat it with the same seriousness as you would treat a formal information request. And you should document all exchanges of information so that you have at least an email trail of what has been asked and what you have provided. Once you get an inspection report in draft, you should review it and you should provide a response to the agency. You should recognize, though, that the agency, again, is not going to accept a red line of the inspection report. You should recognize that your comments are unlikely to change the report. They're very resistant in the program to changing the inspection report because it is the inspector's observations that they're reporting on. But if they've gotten something wrong, if they're applying the law incorrectly, if there's really a defense here, it's important that you put that into your response to that inspection report. Recognize they're not going to change it. Acknowledge that they're probably not going to change it when you respond, but get that stuff on the record because the folks who are making decisions up the chain will review what you've provided and make decisions on what they include as counts based on that. How do we respond to formal EPA information requests? Look, there are broad authorities here, and the agencies make incredibly broad requests with broad instructions. You should take great care in responding. You should provide any necessary qualifications to the statements you're making. You should list any objections you have. Wow, you're asking for thousands of documents. You don't really want that. You should clarify your reading of the broad instructions that they've given. If there's something that to answer would be absurd answering it that way, recast the question and say, here's what I'm trying to answer. Here's what I think you're trying to ask. Ultimately, there should be a statement that effectively says, we're doing our best to answer your questions based on our current information after a reasonable investigation into the documents we would expect to be responsive and the people we would expect to have responsive information. And we're trying to respond based on what we believe you're interested in. While this is required, you should also be sure to reserve your rights to supplement and your rights to update if you don't learn that something's wrong. And ultimately, you need to confirm that the report is accurate, complete, and not misleading. That's just a baseline for any conversation with the federal government. But certainly something that you would do when you have to certify accuracy under penalty of perjury. Okay, over to the TCEQ process. TCEQ typically does involve inspections more so than on the EPA side. At the close of an on-site inspection or a day or two later by email, the inspector is going to share an exit interview form that looks like this. It's going to list out alleged violations, AVs, potential violations, PVs, other potential issues, and records requests with cites as appropriate. This is a first look at TCEQ's takeaways from the inspection and should track closely what they said in the closing conference. This provides an opportunity to re-engage with the inspector on new information and on responding to records requests. We often end up then with a notice of violation. This is a letter typically from the regional office that describes the inspection, whether it's an on-site inspection or a records review. And this is going to list out resolved or outstanding alleged violations, areas of concern, additional issues. If this notice of violation process is going to say, if you submit written documentation that you've corrected these items within 30 days, it's likely not to proceed further. It should be the end of the matter, no order, no penalty. The letter also will extend the opportunity for a violation review meeting with the agency if you give them notice within 10 days of the letter but it does try to restrict it to if you have information that they're not aware of. We have the notice of enforcement action, which is the next level of seriousness. This is a letter also typically from the region, sometimes from headquarters. It looks like the NOV in a lot of ways, but it does not offer 30 days to correct and avoid penalty. It does suggest that you can have discretionary enforcement leniency if you do provide evidence of prompt correction, so you want to respond. It invites submission of information or a meeting request if anything's been cited in error, and then it's going to attach a summary of the investigation findings listing out each count. It may also attach a draft agreed order and a penalty calculation worksheet totaling up what the monetary penalty would be for each count and can include a settlement offer or demand. Let's talk about the difference between the NOV and the NOE. This is a determination that TCEQ makes based on a document called the Enforcement Initiation Criteria. They have categories A, B, and C. Category A, you're automatically going to notice of enforcement, situations where you're operating without a required authorization or circumstances where they've agreed with EPA that they'll take formal enforcement or something that's otherwise serious. Category C is for minor or partial failures, really low consequence stuff, and NOV is the worst outcome you're going to get on this. Category B is the middle category. It's not truly minor. It's not as significant as A. You will normally get a notice of violation for this, but if you repeat the same violation you've previously had an NOV on, that can go to NOE. What's the difference here? The NOV, if it's corrected in 30 days, there's no further action, no penalty, no order. 30 days is not hard and fast. If you ask early and provide a reason, you can get an extension of time on that. But you should hit this issue hard. If you got an NOV with items that you can correct, do go after that. Do get those corrected, because if you respond carefully and get that done, you can make the whole matter go away at this stage. In the NOE, however, in TCEQ's view, there's almost certainly going to be an order and almost certainly a monetary penalty. This is the Texas example I've given here. Other states have similar processes, although they're going to have very different nomenclature. All right, so now you're in the enforcement action. What do you do now? First of all, I think important context, almost all of these matters end up being settled. It's very rare that an enforcement action like this is going to be actually litigated. So the focus of my presentation here is how to get the best settlement or even to secure a dismissal of counts or even the whole thing. A formal hearing is rare, but it is available in both federal and state forums if need be. So let's imagine you've received an NOE from TCEQ, or you've received a show cause or NOV or a list of counts from EPA, and the agency has invited negotiation, has invited a response. How do you respond? First issue is there even a violation? So you've done some investigation based on what they've told you were the issues. Have you looked at this to determine that they've got the facts right? They're almost always going to have the easy facts right. You didn't do these inspections. You didn't have those records. If that is a wrong fact, you can correct that. Usually it's more complicated facts that are tied up in regulatory issues, scientific issues, and factual issues, sort of as combined issues. Was that a hazardous waste at a given point? These are issues that are real fact fights that you can have. Have they gotten the law right? Are they misreading or overreading a regulation? Is the law fuzzy? In particular, look closely at definitions. The definitions are so key to the way you interpret any of these regulations or permit terms. Are there arguments for pushback available in any of these sources of law? Is there an exemption, an exclusion, an affirmative defense that the agency hasn't credited? One thing that I'm always sure to look at the federal level is statute of limitations. The agency inspectors, for whatever reason, don't seem attuned to the fact that there's a federal 5-year statute of limitations on most environmental violations. I had a recent EPA DOJ case where the agency lost 2/3 of the counts they had alleged because they were outside the 5-year statute of limitations. Corporate identity is a big thing as well. It is very frequent that facilities these days change hands, that they are sold or purchased. I had a recent EPA RMP enforcement case where it turns out that the stuff that EPA was complaining about were largely committed on the prior owner's watch, and they lopped off 9 of the 12 counts we were facing. There's also a lot of guidance out there. The agency says a lot of things in a lot of different places about what these laws mean and what they don't mean. Those can be really helpful to you in making a defense on what the law is. So All of that being said, you've pushed back on the facts, you've pushed back on the law. There are going to be some arguments where they're probably right. Whoops, I didn't do that inspection. Whoops, I did make a mistake in that filing, right? But are there mitigating circumstances, or is there contextual information which might excuse or at least provide some softening of account? We had an argument about, we didn't do that inspection. It would have violated OSHA rules to do the inspection as described, right? We couldn't build this containment the way that you asked us to because it would be unsafe. There are defenses that are potentially available from impossibility or at least just context. There are timing issues that can, I didn't do that on time. It's because of X. Those are reasons that an agency can hear. The agency will also likely have proposed a penalty amount, count by count, based on the applicable penalty policy. TCEQ has a general penalty policy for all media, all statutes. EPA has penalty policies by program, air, water, waste, etc. You're going to want to look at whether they've classified that properly. Each of these penalty policies is going to have sort of a matrix they look at. Is it a major, moderate, or minor deviation from the regulatory standard? And then does that have major, moderate, or minor consequences or seriousness? How bad could it be? The TCEQ policy looks at, did you have an actual release versus a potential release versus just a programmatic violation, something paperwork or otherwise? Was the harm major, moderate, or minor? Is it a major or minor facility? They're going to look at those kinds of questions to determine whether the penalty should be big or small. You can look at all of those things, and many of them are gray, and you can push back on whether that was major versus moderate versus minor. They're also going to provide a list of aggregating or mitigating factors. Things like, what's your compliance history look like? What was your culpability here? Is it a repeat violation? Did you make a good faith effort to comply? Most of these are gray and can be argued about to make penalties get smaller. What about the injunctive and other non-monetary relief? On the injunctive side, TCEQ has what they call ordering provisions that are included in your agreed order that basically say fix it. It's like, hey, here was violation 1, you failed to do this, do it right going forward. EPA tends to be much more elaborate, provide much more detailed injunctive relief, install this kind of pollution control, take these kinds of actions. EPA also will often include mitigation or offset requirements and sometimes include third-party audits and certifications. I would say those latter two are less frequent under the current administration than they have been historically. All right, so once you know what your arguments are and you're getting ready to have this conversation with the agency and do all of this pushback, you should do a careful think on the big picture approach to settlement and scope. My instinct is always to first say, how can I knock out counts? How can I make this narrow? How can I reduce the penalties and get this to be the smallest enforcement action it can be? There are other circumstances, and it can be issue particular or it can be across the whole scope of the enforcement action, where a broader order may sound worse, may involve more penalties, but if it's stuff that's gray that you're worried about exposure to going forward, getting that resolved in this enforcement action, getting the most final release and resolution may be a better outcome for your client than trying to fight every count and making it narrow. You need to decide in each circumstance how you want to approach it and how to obtain the best overall result for your client. I want to talk about a related note here on sort of which type of order and what the scope looks like. The TCEQ process includes two categories of orders. There's what's called the 1660 order, named after the Senate bill of the same number. This is a process, this is a type of order that allows you to make no admission as to any allegation. It will affirmatively say the issues in this order are in dispute, and the agreed order will not be admissible in any legal proceeding except a proceeding to enforce that order itself brought by the government. Those are really cool features to have in an order. The alternative is what they call a findings order. This is a circumstance where the agency finds there's been a repeat violation, there's been actual significant exposure to the public, or that you violated a prior order. This findings order doesn't allow you to have that non-admission language. It will say these are the violations, and by agreeing to the order, you're agreeing that those things have occurred. This obviously is more serious in terms of how it's perceived. It's more serious in terms of its hit to compliance history. And it gives you way less ability to say later on, hey, I settled and paid this small penalty rather than fighting. The findings order tends to be a much bigger deal. So let's turn finally to our takeaways here. Environmental enforcement actions are a serious issue for companies. Not only are the penalties potentially significant, there are cases where the penalties run into the millions and sometimes even into the billions of dollars out there. Obviously, the latter are for much more serious incidents. But enforcement actions also create constraints on what you can do going forward. They box you in permitting and enforcement actions on certain issues. They are a huge distraction. I mean, it really takes a ton of time to respond to and defend an enforcement action. And you're worried about compliance going forward while you're in enforcement, right? And there's also the reputational hit. This is a big deal. I do want to emphasize, though, that defending enforcement actions is not about excusing misconduct. The agencies often overreach. They often say things too broadly. They often seek penalties that are inappropriate, don't fully contextualize things. Defending enforcement actions is about making sure that the final answer you get to, that final order you enter into, is right and it's fair and it actually fits the facts on the ground. If you carefully investigate the facts and research the law and apply the law to the facts, you can almost always help yourself in a negotiation of that final order or in a formal defense if need be. But I've not encountered a circumstance where I haven't been able to find something that the agency has alleged, something that they've sought that's grayer than they seem to think it is. It also helps when you know where the agencies have room to move. I think a very common thing is for people to roll in and say, this shouldn't be a notice of enforcement action. This should just be an NOV. And they haven't looked at the enforcement initiation criteria and realized, there's this list of things that TCEQ has agreed by memorandum of understanding with EPA that they're going to commence as formal enforcement actions. They have no room to move on that. Knowing where the areas of squish are is really important. Finally, again, going back to a theme that I talked about right at the top, the best answer is obviously avoiding enforcement. Yeah, we're going to do the best job we can helping you defend the enforcement action. But if you can avoid enforcement through a robust compliance program, and I think everybody thinks they have a robust compliance program, you need to also test to make sure you can demonstrate compliance. If somebody is asking you the hard questions, do those documents really show what you think they show? Are you really going to be able to stand up to critique? Are you going to be able to stand up to questioning on those things? Finally, you should thoughtfully use, as part of this testing, as part of your compliance program, you should use audits, self-assessment of compliance. You should take advantage of the audit disclosure opportunities that are out there to get penalty immunity where issues surface. There are great opportunities both at the state level in 20 plus states. TCEQ has a great audit program available. EPA also has a great audit program available via e-disclosure. There are some circumstances where you don't want to bother with that, but there are some issues. I'm thinking Tier 2 and TRI issues in particular. Man, those are great ways to knock out potential enforcement actions before they happen. So those are my big picture thoughts on how to defend enforcement actions and how to prevent them in the first place. Are there any questions? So first question across is, do you recommend checking into the audit privilege allowed by TCEQ? Absolutely. So Texas has an Audit Privilege Act that allows you to do two things. Number one, if you self-assess, that document is going to be privileged. In other words, it can't be used as evidence against you in a state proceeding, civil or administrative, and that's important. But the more important feature, I think, of the audit program is the ability to obtain immunity from penalties. If you are just looking at your compliance program overall, or if you have a particular concern, I think this doesn't look quite right, you should send in a notice of audit to TCEQ. They have a great guidance document that tells you how to do this. I'm happy to talk with anybody about how to do this, but you send this notice in to the state that says, I'm going to do an environmental compliance audit of this area at this facility. And if you find stuff that's out of compliance, you make that disclosure, you fix it, you are immunized from penalties as a matter of law. That is a huge opportunity, and I would not overlook that opportunity if you have the chance to take advantage of that. All right. I don't see any other questions at this time, so we're going to go ahead and wrap up. But again, thank you so much for taking the time today. And if there are questions that come in after or by email, I'll answer you separately. Thanks so much.